Constructing a Positive Customer Relationship by Deborah Bond, Head of Commercial Litigation at Dine Solicitors. It may seem like a basic common sense thing, but the starting point for any successful court action is knowing who your defendant is. This means that at the outset, when opening your account with your customer, you must know who exactly you're trading with. When your customer completes an account opening form, make sure you are clear who is providing you with the instructions and whether or not they are actually the legal personality you are doing business with. You may speak daily to Mr. Smith, but Mr. Smith, is he the customer, or is he simply an employee of a firm or a limited company? If you're dealing with a limited company, take steps to check on them at the initial stages, obtain their address and that of their registered office. Check the name of the company on the Companies House website to make certain you have the correct details. Are they limited, spelt L-I-M-I-T-E-D, or limited, spelt Ltd? An incorrect name can cause problems later down the line. If your new customer won't give you the information you seek when you first open an account with them, then they certainly won't be helpful once they're in default. Obtaining the correct data at the outset is crucial to the smooth running of the customer relationship and will give you peace of mind going forwards. Remember, a good customer will normally act reasonably. There can be no valid reason for them not assisting and clarifying their details with you. Carry out basic credit control checks with an approved credit reference agency. Ascertain whether or not your new customer has any county court judgments registered against them. Make sure that your new customer is solvent. If they're not, then should you be trading with them? If you are dealing with a firm or an individual trading as, find out who exactly is behind the trading style. You need to have the individual's address, both personal and business, and ensure all spellings are correct. Remember, a trading style is not a legal entity. You don't sue the trading style. Again, check all details. Search the insolvency register to ensure that they are not undischarged bankrupts, and obtain a credit report to see if they have any county court judgments registered against them. Keep your admin team up to speed with your procedures and have very good and clear procedures for documenting customer details. Make sure your admin team keep address details up to date. If you've been notified of a change of telephone number, for example, make sure you know why, and that the whole of your contact information for that customer doesn't then need to be updated as well. If your customer moves premises without telling you, and you later serve court papers on an obsolete address, the defendant will have grounds to set aside any judgment order you obtain. This buys the defendant more time to hide assets and can delay the court process for months. Take a photocopy of checks which you receive a payment for. Use this as a reference point. A clear sign of trouble is when the payer changes. Make sure that your credit control team are alert to changes. Individuals who use more than one bank account or pay in different names could have a perfectly logical reason for doing so, but often this can be an indication of financial difficulties. Consider obtaining personal guarantees from the directors of limited companies. This is particularly important when dealing with a sole trade, a single director who is the sole shareholder in the company. If you have to make a claim for a non-payment, never start a court action without sending a letter before claim first. It may seem like a duplication of work. It may seem like an unnecessary step, especially if you've been in discussions over the same issue for weeks with a customer, but time spent getting this right saves wasted costs later on. There are potential adverse cost implications if you fail to send a letter before claim. Courts today want to see a willingness to engage in active dialogue to resolve matters. Litigation should be considered to be the last resort. Always make sure you have indicated your openness to alternative dispute resolution prior to litigating. Again, a court can make an adverse costs order even if you win your case, especially if the matter could have been resolved outside of the court process. Above all, make sure you bring your claim within time. For unsecured debts, the limitation period is 6 years from the date the cause of action accrued. You cannot pursue a debt through the courts after 6 years has elapsed. This limitation also applies to claims brought against you out of time. There are exceptions to this rule, but the 6-year period applies to most types of debt. If you have a claim or you need help with a claim that you're defending, contact Deborah Bond today.